Hello, how are you all? Welcome to my channel Law Made Simple with me Vidya Reddy. Today in the series of Public International Law, let us learn about what are the sources of international law and how these nations or states are binding with each other using these sources. Sources are nothing but any legal system which derive the authority. The sources articulate what the law is and where it can be found. Different jurists have interpreted the term sources in different ways. According to some writers, sources of international law means evidence of certain rules of international law, and other group of jurists said sources of international law as certain historical facts, long-standing usages and treaties which involve the consent of the nations to be bound by certain rules. We have Professor Oppenheim, who said customary treaties are twofold sources of international law based on implied and express consent. He also said that judicial reasons are also a source which international laws are binding with each other. So let us learn some of the sources. Custom, international conventions or treaties, general principles of law, judicial decisions, writers and jurists are some of the sources of international law. Custom is a foundation stone of modern international law. It was so because a large part of international law consisted of customary rules. Customary international law is a result from the general and consistent practice of the state, which is followed from a sense of legal obligation. Sometimes a question arises as when a general practice or usage is regarded to have transformed into a customary rule. Because since custom is not a law creating a fact, customary rules do not grow up by themselves. It is a necessary condition for the creation of customary rule that at least some states should initiate that a particular rule exists. So in order to make it established, we need three elements, that is duration, continuity and generality. Duration is nothing but when the states practice it for a long duration, it has a tendency to become custom. Uniformity or consistency. If it is practiced or followed consistently by the states, and it is given also in the permanent court of justice in the case of Lotus case that practice should be constant and uniform. Generality. It is essential that uses should be practiced by most of the states in order to transform into a custom. It also implies that there is no rule which prescribes that constant consent of all the states is necessary condition for the formation of customary rule. So, it implies duration, uniformity or consistency and generality are three elements which are required to form a custom. There are two leading cases in this regard. In the case of West Gold Mining Company Limited versus R, in this case, a test was conducted regarding the recognition of custom, whether the custom is a valid source or not. The court ruled that for a valid international custom, it is necessary that it should be proved by satisfactory evidence that the custom is of such nature that it has received general consent of the states and no civilized state shall oppose it. So in the case of military and paramilitary activities in and against Nicaragua, the World Court observed that if a state acts in a way prima facie incompatible with a recognized rule but different its conduct by appealing to exceptions of justifications contained within the rule itself, then whether or not the state conduct is in fact justifiable on the basis the significance of that attitude is to confirm rather than to weaken the rule. So in this case, there was a recognition regarding the custom as source of law. The second case is right of a passage over Indian territory, that is Portugal versus India. In this case, International Court of Justice pointed out that when in regard to any matter or practice, two states, if they follow repeatedly for a long time, it becomes a binding customary rule. The next source is treaties. At present, international treaties are the most important source of international law, which is present in Article 38(1)(a) of the Statute of the International Court of Justice. It lays down that the court, while deciding any disputes They apply international conventions whether general or particular, establishing rules especially recognized by the contesting state. In preference to other sources of international law, treaties have a very dominant importance in international law. Even though the customs and treaties are in practice, which are the most principal sources of international law, they cannot be regarded as only sources. We have other sources of law like general principles of law recognized by civilized nations, where Article 38, Clause 3 of the Statute of the Permanent Court of Justice has given importance. So, the other principles which like good faith, reciprocity, presumptions, res judicata, these are also general principles of law which are also considered as some of the sources of international law. Next comes the judicial decisions. Judicial decisions are subsidiary or secondary means of determination of rules of law which are not direct actually, but they are indirect source of international law. It is because the decisions of the courts do not create any precedent. They have no binding force except to the parties to that particular case. However, subsidiary doesn't mean secondary. It means in many areas of international law, judicial decisions does not constitute the best means of ascertainment. Next comes the writings of the jurists. The statutes of the International Court of Justice has also laid down the teachings of highly qualified writers and jurists and publicists forms some of the sources of international law. Next is the equity. The term as a source of international law is used in the sense of consideration of fairness, reasonableness, equity, good conscience. These are the policies which are necessary for the sensible application of the more settled rules of law. The next is the resolutions of the General Assembly. Resolutions of the General Assembly of the United Nations do not possess legal character and they are not such binding to the states. They do not create much of legal obligations on its members irrespective of the fact that they have been adopted unanimously or by overwhelming votes, or even if their contents are matters of common interest to all the states. So these are some of the sources of international law which have so much of binding force between the states for peace and cooperation between the states.